to this side of the class, but I'm also talking to the camera because this is the training that we're going to put up online for people who are watching this online. So I know some of you, but not all of you. My name is Melissa Hart. I am a professor here. I'm also the director of the Byron White Center, and worked with some amazing students, Lydia Loken and Dado So, and Robert Rogonin, to put together this Constitution Day presentation. As I emailed you yesterday, over the next couple of days, we'll be trying to put people together with classrooms that work. It's a sort of gargantuan job because you all gave us your schedules and the teachers gave us their classroom times, and we have to see if we can make things match. For most of you, I hope we will be able to, but I will. One of you just mentioned to me that he or she is not very good about checking email, and I have to ask whether over the course of the next couple of days, I would be really grateful if you could check your email and get back to us. And us, it will probably be either me, Melissa Hart, or an email from the White Center email account. Because if the class time doesn't work for you, we need to try and find someone else to do it. So it's sort of a constantly moving process. So this year's Constitution Day lesson plan is about voting rights, voting and the Constitution, which seem to be relevant for this year, given that we're all voting, and given the amount of activity on voting rights that's been going on in the states. And what I'm going to try to do during this presentation is walk through what the materials that you'll have, what our expectations are of what you'll do in the classroom, and then answer questions about how the lesson goes, and sort of do a bit of a demonstration of the lesson. So everyone in here I think should already have this handout, which is styled as sort of a letter to presenters. It includes in this material the lesson plan, and then, well, I guess this is in fact the lesson plan. You will also have, or need to get copies of, handouts that you will give to the students. And before you go into the class, I will have emailed teachers copies of the cases the case summaries that are in this lesson plan. So our hope is that the students will have looked at the cases before you even get into the classroom. The reality is probably about 30% of them will have and 70% of them won't have, and you'll just have to assess when you get in there, does it seem like they know what these cases are about or not. One of the challenges in putting together a lesson plan like this is that some high school classes are 50 minutes long and some high school classes are 90 minutes long, and that's a really different amount of time to do a lesson. I think this lesson is really designed for a 90-minute class. To really get through all of this, this is a 90-minute lesson. So one of the things that I want to offer to anyone who's in a 50-minute class is that I'm happy to share ideas about how I think it could be easily shortened. What are the pieces that would most easily come out? Because I do think it will need to be modified. And there are even a few classes, as I looked at the schedule, that are more like 45 minutes. That clearly will require modification. But assuming that you have 90 minutes in your class, the idea is to go in and to start by introducing yourselves. Tell them who you are, where you're from, just a little bit. You can say something about Constitution Day. On this lesson plan, we have, every time there is italic language on the lesson plan, it's some suggested things to include. It's not something that we expect you to sit here and read it like this. In fact, please don't do that. But it's just some information. What is Constitution Day? It's September 17th. In the mid-1900s, President Truman signed a bill that said it is recognized as a federal, not a holiday, but a federal day of recognition of the Constitution. So part of why we're doing this is because any school that receives federal funding has to do something to recognize Constitution Day. That includes CU, and that includes public schools. So they don't have to do this, but this fulfills CU's Constitution Day obligations, and for the schools that are looking to acknowledge Constitution Day, this is a good way for them to do it. The handout then goes on to talk about the fact that we're going to focus primarily on the 14th Amendment to the Constitution. You can, if you want to, test quickly to see how much the students know about the Constitution by asking them if they understand that the 14th Amendment was not in the Constitution that was signed on September 17th, 1787. Probably they will. And then I think some people like to spend a little more time talking about what the original Constitution covered, which is sort of the structure of the federal government, relationship among the branches, and relationship between the states and the federal government, and then talk a little bit about how the Bill of Rights address sort of rights of people vis-a-vis their government, and amendments moving forward addressed contemporary, at that time, problems. Again, I think if you have a 50-minute class, you're going to skip all that. If you have a 90-minute class and people are interested, you can spend a little more time talking about that. We then start with an introductory activity on voting and voting rights to get the students to think about the choices that we make about voting. And I think I actually really like this exercise as a way to get participation going. I think one of the key things to having classes go well, I think any type of class, but certainly a high school class, is to be as little of a talking head as possible and get as much participation as possible. So the handouts that you'll take with you, and again, I'll have copies for people to grab from the law school, or for people who aren't at the law school, I'll email copies that you can print out. The handout starts with this question at the top of the page and asks students to fill in an answer. So that the question is, in your opinion, who should be able to vote in an election in the United States? Or should not, you can say it either way. We also have this PowerPoint that Robert and Lydia and Dado put together that we will send to you, so that if you want to have the PowerPoint up, you can. My experience in doing this is some classrooms have a really good setup for doing PowerPoint and still having sort of space to move around, and some classrooms don't. So I think being kind of flexible about which way you do it is good. The PowerPoint doesn't add a huge amount, but it does sort of repeat a lot of the information that's on the page, so that if students want to focus up here rather than on their own page, they have that. They can be sort of more engaged in the class rather than on their own page. So with this introductory exercise, and I guess I want to ask you guys, what do you think people will say? Either you can tell me who, in your opinion, do you think should be able to vote, or what do you imagine high school students are thinking about that?
I think similar to Brian's, like everybody should vote.
Everybody should get to vote.
Yeah.
I suspect some number of people will say that, yes. Other possibilities? John?
Depending where the high school's at and what kind of the political needs of their family, they'll probably have an answer that's not to only citizens that show ID and et cetera, et cetera. So.
Okay, yeah. So I mean, some kids will have actually had this conversation around their kitchen table, and they will have opinions about it that are developed in part by their parents and what their parents' views are. Some kids will say, I think some of the lines that you're likely to see drawn are, some people will say we should be able to vote if we're 16 or older. Some people will say only educated people should be able to vote. Certainly, I'm sure people will say only citizens. Then a question of what do you have to do to prove you're a citizen? The question was just raised, what about people who are in jail, or people who have served their criminal sentence? Should they be able to vote or not? Those are sort of some of the lines that we do draw. And so just getting that conversation going. And then again, looking at the handout, the sort of next step, I think, is to say where in the Constitution is the right to vote. And we talk about voting as certainly a right that people have. Where is that right found in the Constitution? What do you think they'll say? A lot of students think it's in the First Amendment.
Yeah, that's my guess.
And there are certainly constitutional scholars who have written and said they think it's grounded in the First Amendment. It's certainly not textually there in the First Amendment. It's not actually textually anywhere. There is no right to vote specified in the Constitution until we start talking about the right to, that some people shall have the same right to vote as citizens. And so there's an implied there that there is a right to vote. There's, again, in the handout a little bit in the text about what a small percentage of people could vote when President Washington was elected. About 6% of people in the country could vote. And again, you could say a little bit about the history that we went from only white men who owned property being able to vote to a gradual expansion to all white men. And then we hit the point that we're going to be talking about, which is the passage of the 14th and 15th Amendment. So, and I'm not running through all of this history because we have a lot to get through in an hour, but there's a little bit more of the history on the sheet if you want to go through. And then we come to the 14th Amendment. And again, on this handout that the students have, I think you have some discretion about how much you want to use it. What's useful about a handout like this is it forces the students, because they have to write in some of the text of the amendments, just forces them to pay attention. For some students learn by hearing, some students really only learn if they're writing something down for themselves. So it just kind of captures different learning styles. That's part of why it's helpful to have something like this. So you should ask one of the students, ask for a volunteer to read this part of the 14th Amendment, and ask the students in the class, again, it's your discretion how much you want to use this, but to write in the missing parts, which are missing here and underlined there, for the 14th Amendment. I think at this point in the materials, we sort of keep going to the 15th Amendment. If you want to stop for a moment and sort of ask, what does this mean? What was the purpose of the 14th Amendment? What were they trying to do with it? The one thing I should caution you on is, it's been my experience in talking to high school students about the 14th Amendment that they get very caught up with the what's privileges or immunities. Privileges or immunities sounds like it must be the most important part of the 14th Amendment, and trying to explain to them that because of the way it's been interpreted by the Supreme Court, it possibly could have been really important, but it just isn't really important, can take up time. So I would, if you're going to sort of talk about what does it mean, I would focus them on what do you think that the framers of the 14th Amendment meant by equal protection of the laws, since that's where the discussion is going to focus and really where most of the oomph of the 14th Amendment comes from. So then we go on to the 15th Amendment, which was passed shortly after the 14th Amendment, and specifies that neither state nor federal government can deny the right to vote on the basis of race. So, and this is the first place that the right to vote is specifically mentioned as a right to vote in the Constitution. And that's what to say about the 15th Amendment. In the handout, again, you don't have to read this word for word, but we then go on to talk a little bit about how even though the 15th Amendment guaranteed the right to vote, or said that it couldn't be denied on the basis of race, states, and particularly southern states, passed all sorts of laws that didn't explicitly deny the right to vote on the basis of race, but made it impossible for former slaves or black citizens to vote. So whether it was literacy tests or poll taxes or grandfather clauses, all sorts of laws were passed that essentially, without mentioning race, made it impossible for African Americans to vote. Yes?
What year are these students?
They will 9th through 12th.
So I'm trying to remember high school, American history, that kind of stuff. Sophomore?
Yeah.
Okay.
Although it actually varies hugely, even district to district. So
Okay.
some of them will have had it, some of them won't.
So we shouldn't expect them to know what Jim Crow means. Because my parents don't even know what that means, and they're like, that's scary, but it's the truth.
Again, I think some of them will and some of them won't. I think most of the teachers who are inviting us into their classrooms, I mean, these are people who are teaching civics or U.S. history or
Sure.
government, and so
Okay.
they're interested in this, and they knew that the topic was voting rights, so and actually a few of them have emailed and said, really specifically, we would love you to talk even extra about the Voting Rights Act, which is
Okay.
not specifically here. So I think it'll vary some, but you can also, once we know what your assignment is, you can ask the teacher sort of where in the curriculum
Yeah.
are they.
Okay.
But yeah, I mean, some of them won't. I think they'll all know about racial inequality,
Yeah.
but I don't think they'll necessarily know the legal history.
Yeah.
So the next bit of suggested text that we have sort of talks about how restrictions on the right to vote were still in place, gradually leading to the Civil Rights Movement, and that the Civil Rights Movement led to significant changes, including the Voting Rights Act, and a sense that the guarantee of the 15th Amendment really had to be enforced more robustly. And then also, our last amendment that we're going to talk about, the 24th Amendment to the Constitution, which guaranteed that the right of citizens to vote shall not be denied because of failure to pay a poll tax or any poll tax or other tax. Importantly though, and this becomes important for our hypothetical, this is only about voting in federal elections. This is not about voting in state elections. So states could still, even after the 24th Amendment, have poll taxes for voting in state elections. So after going through those, there's sort of 3 different parts to this lesson. I guess 4 parts. There's the introductory activity. There's going through these constitutional amendments and thinking about how the Constitution has been changed vis-a-vis voting. We don't mention the 19th Amendment here, but it would be worth mentioning that women, somewhere in here, women started being able to vote. So the Constitution was changed. I mean, there's been, I think one of the interesting things is the Constitution has changed more because of increasing the right to vote, expanding participation in voting than for any other reason. There are 6 different amendments in the Constitution that have to do with enfranchising people of color, women, people between 18 and 21, anyone, and all of this was a constant expansion of enfranchisement. So then again, the text here, suggested text. Now this I would say, although you don't have to read it, I don't want you to read it, in order to set the problem up, you really do need to talk about recent voting rights laws. And so what the text talks about is the recent efforts by states around the country to pass voter ID laws that either restrict early voting, so not voter ID laws, voting laws that restrict early voting, change voter registration rules, and require photo IDs to vote. And we tried in this text to say the reason that that supporters of these laws say they are passed is to prevent voter fraud. I think it's important to acknowledge that as a stated reason. I think this is one of these areas where I really think it's important for the lesson not to be sort of entirely one-sided, but I also think there isn't really an argument that is plausible that the laws that are being passed stop any kind of fraud that's actually happening. So for example, there is actually some evidence that there's pretty significant, maybe strong. There is some evidence that there is fraud in absentee ballots, but the laws that are passed don't affect absentee ballots. The laws that are passed are being passed to change in-person voting. And there's not a lot of evidence of fraud in in-person voting. Travis?
So do you think along those lines it would be inappropriate to state facts such as that there have been 9 confirmed cases and over 1 billion votes in an 11-year period, according to a couple of law school studies? I mean, can we tell them this? Is that
Sure. All right, so this is great. So, but you have to speak up so that the people on the video camera can hear you.
Yeah, that we could say, I mean, just as an example, just for some news article that I think Loyola Law School just did a study that showed, okay, we found, 7 to 9 confirmed cases in over 1 billion votes from, I'm just trying to go off memory, 2004 to 2011, something like that. So to frame that in context for them, not going too far political, but just saying, look, here's the claim and here's the empirical, or one study's empirical reality.
I mean, I've heard pushback on that number you're using, so I don't really know if using things that detailed would be good.
Well, if we use the source, I mean, look, we just say according to this,
Right.
this study.
I think you can, I mean, so I think that's right. I think this is, I think what's, it seems to me in talking about this, I think we have to acknowledge that whether we believe any particular source or not, nobody has been able to produce significant evidence of in-person voter fraud, A. But I also think we need to acknowledge that people have to present identification to do all kinds of things. You have to present identification when you're renting a car. You have to present identification when you're checking into a hotel. And so the argument that why shouldn't you therefore have to present identification when you're voting is not an argument that should be thrust aside lately. And I think that's, rather than, I think the better arguments on this is a hard-fought debate, obviously. The better arguments are not so much this will prevent fraud, because it really won't, and just why not? Why not have to do it given everything else that you have to present an ID for? And I think importantly there, and this comes up in the hypothetical that we have, it's really important to point out for students that the question is not absolutely no ID, you can just go in and vote, or one particular form of ID. The question is, I don't think any states have you can just walk in without ever having registered and cast a ballot. I think every state requires you have to register, at which point you might have to present some form of identification, or you have to bring in one of a range of different kinds of proof, whether it's a utility bill or some kind of proof that you do live in the location where you're voting. But anyway, this is a hard issue to talk about because people have strong feelings on both sides. But we mentioned the Texas law, talking about the Texas law in this text. And then I think this map is helpful in terms of looking at what kinds of, so there are a number of states that have no document required to vote, but I do think it's important to point out there that you do have to register to vote, so at some point you had to present some form of document. Again, I don't know of any state where you can just walk in and say, hi, I'm Melissa, I'm here to vote. So spending a little time, I think, talking about these voter ID laws and the fact that the fact that people argue, and again, we have a case here that we can use to talk about who they disenfranchise, but talking a little bit about what the arguments are against them, that they make it the people who are primarily affected by them are people who are poor, tend to be minority voters, and very clearly tend to be voters who vote as Democrats. And I think, again, you have to decide what level of sophistication the students that you're working with are, but it's not unconstitutional to pass a law that will make it harder for Democrats to vote, or that will make it harder for Republicans to vote. It may be, very partisan and political, but it's not unconstitutional. So the question that would make it unconstitutional is, are you passing a law that makes it harder for people to vote, people of color to vote, people who are in a protected class to vote? And that's a different question. You can say I don't like voter ID laws because they're targeted at making it harder for Democrats to vote, but that's a policy argument, not a constitutional argument. So sort of trying to keep that separate, I think, is important. So then the next piece of the lesson plan, having talked about these voter ID laws, you can then say to the students, now we're going to discuss a hypothetical that presents a scenario where a state passes a voter ID law. But before we do that, we want to give you some cases, which is what you'll use as tools to make arguments, because this is what lawyers do when lawyers make arguments about whether something's constitutional or not constitutional. They may make some policy arguments, but they have to be able to ground their arguments in case law. Those are the tools that we use to make our arguments. So we're going to give you 3 tools, 3 cases that are two of them are from the Supreme Court, and one hasn't gone to the Supreme Court yet. And then we're going to ask you to use those cases to try to make arguments about the hypothetical that we present. So the cases that we have, again, ideally they will have read these cases before, but I think you have to expect that they might not have. There are a couple of different ways that you could do the cases. I think if you have them seated this whole time and you're just having them read, that will go faster, like having them read out loud. That will go faster, but it will also be less interactive and more boring. One method that could work with something like these 3 cases would be sort of I'd call it each one teach one sort of. So you could divide them into 3 groups. Have a third of the class read Harper against Virginia State Board of Education, a third of the class read Crawford against Marion County Election Board, and a third of the class read NAACP against McCrory, and then put them, once they've read them and thought about them, put them into groups of 3 and have them teach each other about the cases. That's one good way to sort of force them to be engaged, and as you do that, you go around the classroom and talk with different groups about the cases. I think, again, in a 90-minute class, you'll have time to do that, and that might be a good way to get them engaged. In a 50-minute class, I think it's probably not realistic to ask them to do that. And in that case, I think you probably will need to give them some time to read on their own, and then ultimately have students read out parts of the case. And I would suggest sort of going around the room and getting students, the students read a couple of sentences, the students read a couple of sentences, just to keep people talking. Again, we have a place to take notes on the handout in relation to the cases. We have a section for the rule from the case, a section for some notes about the case. I would encourage them to pick out a pretty straightforward rule from the case. So for example, with Harper against Virginia State Board of Elections. So Annie Harper was one of several people who were part of a class action in Virginia who argued that requiring the payment of a poll tax to vote, this was again at a state level election, so the 24th Amendment eliminated poll taxes in federal elections. Annie Harper and her class of plaintiffs argued requiring a poll tax also violates the 14th Amendment. So it imposes an unreasonable burden on your right to vote and therefore doesn't provide equal protection of the laws. That was the argument. And the court looked at this case and said that the rule is the Equal Protection Clause of the 14th Amendment prohibits states from requiring the payment of a fee or tax in order to vote. When a state, and I guess I actually think this is the piece that I would want them to take away, because it's the general piece. When a state imposes a burden on the right to vote, that burden must be related to voter qualifications. And this is a principle, when you guys, most of you are 1Ls, I think when you take con law, you'll see that this principle, it runs through all of con law in different ways, right? If you have a right that's protected in the Constitution, that doesn't mean the government can't burden it. The government does in fact abridge our free speech on a regular basis. There are in fact legitimate gun control laws, but it does mean that if there's a constitutional right, the government has to provide a significant explanation for why it's imposing a burden, and that burden has to be related to a legitimate government need. So here we have the right to vote, and the court says you can't impose a burden on the right to vote that is unrelated to qualifications to vote. And the ability to pay money is unrelated to qualifications to vote. We from the very poorest to the very richest, we all have the same right to vote. So that's the rule that's set out in Harper. In the instructions here, I suggest that if you want to, again, depending on how you do the case summaries, if you have time, you could ask a couple of questions about each case. So, for example, why isn't wealth related to voter qualifications? Again, I think it sort of depends on what the class, if the class seems like they want to engage, if this seems like the level that they're at, or think about what would be a requirement that would be related to voter qualifications. So the ones that I suggest here, would a requirement that a voter demonstrate that she is 18 or older be related to voter qualifications? Yes. If only 18-year-olds are permitted to vote, then at some point, whether it's when you register or by presentation of an ID when you vote, that would clearly be related. So just again, getting them to think about what does that mean? Because there are burdens that can be placed on the right to vote. Any questions about Harper? Okay. So then going on to Crawford against Marion County Election Board. This is a case that challenged Indiana's law on voter ID. One of the things that's tough about this case, I think it's actually it's very tough, is that the Supreme Court in Crawford, in this sort of complicated, divided opinion, rejected a challenge to Indiana's voter ID law. And they rejected the challenge saying, essentially, there's no evidence presented here that convinces us that this is an impermissible burden. Justice Stevens, writing for the court, said, we take as a given that prevention of fraud is a legitimate state interest. And he said, so that's taken as a given, so there is a strong state interest. And there was no evidence presented that this law burdened anyone's right to vote. So the plaintiffs presented not even a single person who said, I wouldn't be able to get the kind of ID that's required here. So this is a total lawyer's case, because on the one hand it sets out a principle, which is Indiana's voter ID law doesn't violate the Constitution. On the other hand, it's a principle that it does not mean all voter ID laws are constitutional. It means this case was poorly litigated, is really what it means. In this case, the plaintiffs failed to present the kind of evidence they needed to present to meet that standard that was set out in Harper of an impermissible burden that can't be justified by a legitimate state interest. So it's challenging, I think, to talk to high school students about why this case doesn't just answer the question, why this case doesn't mean all voter ID laws are always fine. And it makes it, so that would be, I think, the challenge in talking about this with the students. That's why the questions that I suggest asking, why was it important that the plaintiffs did not produce any witnesses who said they were burdened by this law? I think getting people to think about that cases turn on the kinds of arguments that lawyers make. And if you just fail to make an argument or fail to present any witnesses to support your argument, you're going to lose, and that could have consequences. You're going to lose, and now we have a case that says voter ID could be read as saying voter ID laws are always okay. So then my second question, does Crawford mean that a law requiring a particular type of ID to vote will always be permissible under the Constitution? And getting them to think no, like if you said, in order to vote, you have to have a university ID. That would clearly not be constitutional because it would allow only people who had some connection to a university to vote, and that would violate Harper's general principle that voting restrictions have to have some connection to voter qualifications. So you can come up with examples that would never be passed as law, but that would clearly be impermissible, and just as a way to sort of think, okay, so how do we think about which kinds of things are permissible? See, I'm making people in this room yawn, which is a good example of why you should. It was many people.
Time of the day.
It was
Yeah,
many, poor
I'm just
Josh.
tired.
It was many
Sleepy.
people. It's just one of the reasons why you need to have other people talking, not just you. That's the key. All right, so our third and final case is NAACP against McCrory. This is the Fourth Circuit challenge to North Carolina's voter ID law that just went through the Fourth Circuit, and the Supreme Court just decided that it was not going to interfere. So this case stands, and I'm double negativing it, but the Fourth Circuit's decision stands, which means that North Carolina's voter ID law cannot be used in the election this fall. And what significance that will have for the election is interesting, but beside the point for our purposes. So this case is the one that kind of brings in a further element into the conversation about voter ID laws, which is the element of race, which we really haven't talked about before. Crawford very clearly did not bring in any element of race, although the plaintiffs argued that it would impose a burden on poorer people and minorities. They didn't present any witnesses who could demonstrate that. So it was an argument, but it was not an argument with substance behind it, essentially. In McCrory, by contrast, the plaintiffs brought forward evidence that prior to passing this voter ID law, the North Carolina legislature asked for and received data about which kinds of voting processes, whether it was early voting or absentee balloting, primarily those things, early voting and absentee ballots, which kinds of things were used by people along racial lines. And the legislature was provided with the information that in the earliest part of early voting, the 1 to 7 days of early voting, that was used very primarily by voters of color, and absentee voting was used very primarily by white voters. And given that information, they passed a law that eliminated the early voting, but did not make any changes to absentee voting. Now, what was the reason for their doing that? The reason for their doing that, and the court talks about this, is that in North Carolina, voting is both partisan and racially polarized. So African American voters tend to vote Democrat, and absentee voters, and white voters tend to vote Republican. So the changes that they made may not have been made specifically for the purpose of disenfranchising black people because they were black people. It may have been for the purpose of disenfranchising black people because they were Democrats, but that's not the question that you ask. The question that you ask is, were they taking action because of race? And given the evidence, given the history of voting in North Carolina, given the fact that they asked for this racial breakdown of information, not a party breakdown of information, but a racial breakdown of information, and then that they passed a law that tracked that racial breakdown, the court said, we're in a totally different category now than we would be if this was race neutral. If this was race neutral, then the state would have, there'd be a presumption that this law was constitutional, and the people challenging it would really have to prove that it imposed a significant burden. Because there's this evidence of consideration of race, the state now has the burden of explaining that this law was necessary, and overcoming the sort of taint that is created by the inclusion of race. Now, what I just said is not exactly what's written here. I think what's written on the sheet is clearer and cleaner for high school students, but that's sort of basically what went on in the case. And so what we need to get them to think about is this introduction of an element of race and what that does to thinking about a voting law, because of course when we talk about voting in our country, again coming back to the 15th Amendment, the first time the Constitution mentions the right to vote is in saying we are no longer going to deny people the right to vote based on their race. So there's a deep history in our country of protection of the right to vote, of denial of the right to vote based on race, and now therefore of a need to be particularly protective. Yes.
I can't remember if it's the 14th. I want to say it's the 15th Amendment that mentions, like, it goes into detail. It says, like, if states do disenfranchise people, like, we're going to penalize you by reducing your representation in Congress. So that kind of goes to the fact that they were like, yeah, I mean, you can keep discriminating, it's just now we're going to have penalties associated with that. Is that something we should address or get into, or no?
No,
Okay.
I don't think so. I think so that then I realized I should have. So the only part of the 15th Amendment they will have is really that limited piece, and I think there's so much information here, and it's so that one of the things that actually will be challenging, I think, with this lesson is sort of cabining it to the information that we have here, because the right to vote just raises so many different interesting questions, and people will have opinions, which is one of the reasons it will be an interesting lesson to do. I guarantee that the students will have lots of opinions about this. But it also does mean that it will require a certain amount of saying, well, we're going to focus on this piece. So I don't use PowerPoint very much, so I apologize. I should have. So what we did with the PowerPoint with these cases is to try to just have the rule. I tried to bold what I thought was the most important sentence. It barely looks bold at all, does it? But I tried. Yeah. So again, here I think when considering whether discriminatory intent motivated the passage of a law that on its face seems to be neutral, courts must look carefully at whatever evidence of intent is available. Once plaintiffs have established that race is a motivating factor, the state must meet a higher burden to demonstrate that the law serves a substantial government interest. So one of the questions I suggest at the bottom, asking again, depending on sort of what kind of a class you have and how much time you have, is why do you think the legislature passed this law? I think this is one of the things that we get so nervous about talking about, and we've got to be able to talk about it. We've got to be able to talk about the fact that our politics is partisan and that people pass laws to gain partisan advantages. That's what gerrymandering is. That's what these laws are. Also, people can talk about the question of coming back again to the question of fraud, of is there something about voting where it's an important civic responsibility and you should have to show that you are who you are. So I think allowing time to air those arguments is a good idea, whether it's here or before you start talking about it. Again, some of what I've already talked about, I mentioned here, discrimination on the basis of political parties is not a violation of the Constitution. To the extent that there was any intent to affect voters negatively, was it about politics or about race? I think it's worth talking about that. And somewhat depending on the class. And let me just pause here and say, I keep saying somewhat depending on the class. You will find that high school is different than it was when you were in high school. One of the things that whenever I send law students into high schools now, the presence of phones, and not just phones but headphones, is sometimes startling. It's not everywhere, but it's not totally uncommon that there will be people with earbuds in, or there will be people with their heads down on their desk sleeping. Again, not everywhere, but not uncommon. So it's just, you just sort of have to decide, is this a class that wants to get up and argue, or is this a class that wants to see how quickly they can get you out of there, and then work with them on that. Lydia?
I would suggest bringing candy if the teacher allows it, so
Oh.
everybody gets involved for candy.
Okay, great. So Lydia made the excellent suggestion. If the teacher allows candy, bringing candy is a good idea. When I connect you with your teacher, or when we connect you with your teacher, you can check with the teacher. Some schools don't allow candy, some schools do. It is definitely true that as an incentive for speaking up, being able to hand out Snickers bars or whatever. Snickers is a great example. You should check if the classroom has peanut-free or not peanut-free. But,
Make sure it's not special Colorado candy too.
Oh, Jesus.
Don't want to do that.
yes, that is an excellent and terrifying point. So then finally we get to the last and I think usually the most fun part of the lesson plan, which is the hypothetical. So this hypothetical is one in which we suggest that Colorado passes a voter ID law that's actually quite similar to the Texas and North Carolina voter ID laws. The important piece of it is less exactly what the IDs are and more, in terms of getting the students to think about the arguments, more the beginning paragraph. So in our hypothetical, the Colorado General Assembly was upset to find from the Secretary of State, who administers elections in the state, that a University of Colorado student voted twice in the 2014 election. He voted once in his home state and once in Colorado. A group of senators concerned about undocumented immigrants voting was especially concerned about the possibility of voter fraud. This group had read on the internet that undocumented immigrants might be trying to use fake IDs to vote. The immigrants' supposed goal was to ensure that Democrats would win in state races. Because of these concerns and inspired by Texas, the General Assembly enacted a new voter identification law, SB 450. Now a voter in Colorado must present one of the following forms of identification in order to vote in any election. A Colorado driver's license, a concealed carry license, a pilot license issued by the FAA, military ID card, citizenship certificate with photo or passport. Prior to passage of SB 450, voters could use many other forms of identification in order to vote. These included, but were not limited to, a utility bill, a government-issued employment identification card, a photo identification card issued by a Colorado, that should say institution of higher education, or a certified copy of a birth certificate. Facing a budget shortfall, Colorado cannot afford to provide voters with free photo ID. So that's the law that is passed now. And then we have our hypothetical plaintiff, Gloria Lear, who is a retired teacher. She's Mexican-American. She's 92 years old. This is all Lydia and Dato and Robert. She was shocked to find that SB 450 made her ineligible to vote in the upcoming election. She's an avid user of public transportation, so she has never had a driver's license. She has never fired a weapon or had a concealed carry license. She's never been a pilot or a member of the military, and she's never been outside of Colorado. Ever since she first cast a vote, she's used her birth certificate as her identification, but her birth certificate doesn't have a photo on it, right? So nothing that she's used before would make her eligible to vote in Colorado. So she has sued the General Assembly on behalf of herself and all other Colorado voters. She claims that the law violates the Equal Protection Clause. The General Assembly argues that its interest in preventing voter fraud outweighs the burdens on voters such as Gloria. Now, what you will have done, and there are long directions on here that the students won't have, but you'll have, is divided the students into small groups, sort of 3 to 5 students, depending on the size of the class. Ask them to read the hypothetical and annotate it, looking for information that, when you ask them to annotate it, say what are they looking for? They're looking for what kinds of things might show government motive, what kinds of things seem similar to or different from the cases that we've talked about, what are things that seem like they would be important to whether this law passes constitutional muster or not. And then tell them that they're going to have to argue one side or the other. Some of them are going to support Gloria and some of them are going to support the General Assembly, and they're going to use not only policy arguments but also the cases that we've provided them with to try to make arguments about the Constitution and the constitutional amendments that we've talked about to to try to make arguments about the case. So now I'm going to ask you guys for the next few minutes to try to make arguments about this case. What do you, if you were representing Gloria Lear, what would be the things you would look at in the hypothetical, given the cases that we have, to argue that this law presents a constitutional problem?
Cost.
Hmm?
Cost.
Keep going.
Well, Colorado cannot afford to provide voters with a free ID, free photo ID, and if you have to pay to get a photo ID in order to vote, it's kind of like a poll tax.
Okay, good. So it seems, and that's one of the interesting things that has, so in the Indiana case against Crawford, in Crawford against Marion County, Indiana initially faced a challenge that its law constituted a poll tax, and the state immediately said, we'll provide free, anyone who needs a new ID will provide a free ID. So they got rid of the poll tax question by doing that. So in this hypothetical, if Gloria or someone else would have to pay to get an ID, which it seems like they would have to, it seems like that would violate Harper against Virginia and violate the 14th Amendment. That's definitely an argument she can make.
I think I would also include, look, here's a real human who's being impacted negatively by the law. This is not just some fictitious argument. It's no, Gloria is being hurt.
Right, here, so again, unlike Crawford, we can point to a person whose right to vote is being burdened by this law, and a longtime participant in the community who just wants to keep participating in the community. Other arguments that Gloria could make?
Maybe you could possibly tie the fact that they were concerned about undocumented immigrants, well, if it was race-based, you know, if they were basically associating undocumented immigrants with a particular race, with no evidence that they were undocumented or something.
Okay, so is there something, again, it's nowhere near as clear as the issues in NAACP against McCrory, but is there some evidence of negative racial intent or racial assumption in that group of senators' views? There might be something there. Other things?
I don't know if they definitely have a constitutional source, but their methods for figuring out, it's just some internet, something around there that said, oh, it's going to be undocumented immigrants who are going to vote for Democrats or whomever. So the sort of source of the legislature's information.
Okay, good. So I think the way I would frame that maybe is to say, if we're looking at what is the purpose of the law, if the government is trying to prevent voter fraud. What kind of voter fraud? Do they have any real evidence that there's voter fraud based on this internet story about undocumented immigrants who might try to vote? That doesn't seem like strong evidence. What about the evidence that they do have, that this one CU student voted twice? What would Gloria say about that? Nick?
Their solution still isn't effective at preventing this, because hypothetically you can have a US passport as well as a driver's license, and you'd still be able to potentially, under the other states' rules, vote in both states.
Right, so you could say, I think you could say that they have two kinds of evidence. One is concrete evidence of this one particular type of voter fraud that occurred, but this law wouldn't stop that. And then this sort of nebulous evidence of an internet story, is that sufficient evidence, or should we be a little skeptical of that as sufficient to impose a burden on the right to vote? And again, I think importantly, because of the poll tax element of this is not just the burden of having to get an ID, it's a burden of having to pay for an ID. So it makes it a stronger case than any of the other cases in terms of the constitutional infirmity, potentially, of the law. So now what about on the other side? What if you were arguing for the General Assembly? Nick?
I hate to say this, but voter fraud is just so terrible. Any single instance is just grotesque and throws our elections just out the window and destroys any reliability in the entire electoral process.
Your mocking tone. Your mocking tone to the side. Here's what I would argue if I were arguing for the General Assembly. I don't even need to talk about whether you disagree or agree with me about voter fraud. In Crawford against Marion County, the Supreme Court of the United States said it was a legitimate state interest to try to prevent voter fraud. Full stop. That's the holding of the Supreme Court. That's a legitimate state interest. You can't go behind the evidence I had and inspected or question my motives. The Supreme Court has said it's a legitimate state interest, and I'm just following the Supreme Court.
They're not targeting anyone based on their race. They're just specifying which forms of identification work, and they're not basing that, that's it, you know what I mean?
Yeah, this is not like NAACP against
No.
McCrory, there's absolutely no evidence
And
of
they
race
like,
here.
I mean, they could argue, they have like different arguments at their disposal, I mean, other than race or anything like that, because they didn't really, it's not even being charged here, but like, you know, so they removed the student ID from an acceptable ID. I don't even know if that was an acceptable ID before, but if it was, it was. So they could say like, look, students who are young tend to vote Democratic, that's a legitimate interest if we want to do that. Oh, that's not what they're arguing here.
Right.
But I'm just saying like if that comes up amongst the students, like we can just be like, that's, you're allowed to push back and be like, political disenfranchisement is totally okay, right?
Okay, yeah, you wouldn't make that argument in court, but yes, you're dead, but it's not unconstitutional. So I think importantly, this is, if you look at this and say, this is not NAACP against McCrory, there's no evidence of race discrimination here. That means we're in the legal world of arguing in the Harper against Virginia. So the question is, does an imposition on the right to vote relate to voter qualifications? And all the state has to do is show that it does. Does showing that you are who you say you are relate to voter qualifications? Sure it does, of course it does. Does this particular form of saying that you are who you say you are impermissibly burden the right to vote? That's where our problem is, right? Because it's also not like Crawford, because we do have a person. But if I were arguing for the General Assembly, I would say, look, this one, until you can show, if they've been able to find one person who miraculously at the age of 92 has managed to not have a driver's license, not have a US passport, that's one person, and that's not very much of a burden given our constitutionally permissible goal of preventing fraud. So you can sort of look at, thinking about what the burden looks like, this is one of those funny things in constitutional law too. When you think about the burden for Gloria, it's a huge burden. But if you're looking at the burden on the right to vote in the state of Colorado, she's just one person. And so unless there are more people in her situation, it doesn't feel like a very big burden. It feels more like Crawford. So at the end of all of this, and we have just a few minutes left, at the end of all of this, you're gonna wanna wrap things up. You don't wanna, and this is one thing to be really sensitive to as you're going through the lesson plan. You wanna take the time at the end. You don't just want them to walk out after the debate. You wanna end up wrapping things up with some kind of quick conversation. You could ask them, how would you vote if you were judges? I always think that's an interesting thing to do. How many people would rule, who would rule for Gloria, who would rule for the General Assembly? And then I think just say, this is an active debate going on in this country right now. And there are legitimate arguments on both sides. And it's one of the, I think probably one of the most important debates going on in the country. And courts have come out in different ways. So, we read the NAACP against McCrory case. You can also say there are courts in Indiana and courts in Texas that are also looking at this issue, and they're coming out slightly differently. So it's not an easy question. It's not a question where we can say there's a right answer, and everyone who disagrees with that right answer is just wrong. It's in fact a complicated question that will affect elections, and it matters to think about, and that's why we wanted to talk about it today. And the thing I'll close with is sort of the ultimate question is, how do we balance protecting the integrity of the voting process, which I think everyone can agree is an important value. We want to protect the integrity of the voting process. We also want to protect access to the voting process for people who are legitimately entitled to vote. And how do you balance those two things is what's really at issue here. And it's not always a constitutional question. A lot of the time it's a policy question, but the Constitution is always there as something that is a check on some of the arguments that we can make in this debate. Travis?
Do you think it would be appropriate at the end to just kind of talk about, how important it is that they register to vote, and to try to tie it to these cases, try to explain to them, some of these seminal cases are because of voters, someone who was trying to vote, that we wouldn't have these laws unless people were actively trying to do it, and just like plugging.
Yes, I think that's absolutely a good idea, especially because a lot of these kids, we will be talking to people who are either could be voting this election or certainly will be in the next election, and just saying this is your right. and of course it won't be for everyone in the room. There will be non-citizens in your classrooms for sure. I don't know if that will come up or not, but there will be non-citizens in your classroom. But for the people who are gonna be able to vote when they're 18, yeah, we want to encourage them to vote.
What's the law in Colorado? Can they register when they're 17, or like what's, you know what I mean? Can they-
There is some under 18, like pre-registration there.
Pre-registered,
Yeah.
It's not auto though.
It's not, yeah, so, but we could like, if that's an option, we should tell them pre-register first if they want, right? But that's an option?
Yeah, I mean, yeah.
I will find out and send an email about that. That's a
Okay.
great question.
Okay.
What do we do if a student has a Make America Great hat on?
Take it off your class. No hats in class.
I think you just smile and look somewhere else.
That's a good answer.
And that, of course, that definitely could be the case. So, and I do think it's really important, especially with, there may be students who have Make America Great hats on, and as I say, there definitely will be students who aren't citizens. And sort of being aware of that people will have deeply held convictions about this stuff, and it personally affects them, is also something that's just good to keep in mind.
The teachers aren't gonna, they're gonna be aware that like abdicating, like classroom discipline classes, like they're gonna be the ones that are, making sure the students are like respectful to each other.
Yes,
Yeah.
yes. So I have never had the experience that a teacher left the classroom during Constitution Day. They'll be there and they usually will be encouraging participation, sometimes making suggestions about who are good students to call on. So that's one of the things actually I encourage you to do is connect with your classroom teacher ahead of time, and even during class, like if they have ideas about what's gonna make the most sense in terms of reading. Again, some classes it makes a lot of sense to just let them sit and read for a few minutes. Some classes, if you did that, it would be 20 minutes later and they still wouldn't have finished. So the teacher's gonna know the students and will have a sense of what's realistic and what's not.
Can you explain the dynamic? So it's my understanding that we will be going with an attorney, so there will be two of us, or?
Yes.
Okay, and how?
There will be some circumstances where I might email you and say, I desperately need someone to cover this class and you're the only person available. Would you be willing to do it alone? But my goal is to have teaching partners.
And is it just kind of bounce back and forth off of each other with this? And obviously, you probably should have some deference to them with a little more expertise. But
Well, it might be that you're partnered with another student too. I mean,
Okay.
I won't necessarily have, again, people's schedules are so complicated that a lot of it is just about where your schedule meshes with other people. In addition to connecting with your classroom teacher beforehand, I recommend connecting with your teaching partner and saying, how do you want to do this? Do you want to do the amendments and I'll do the cases, or do you want to take the Gloria Lear arguments and I'll take the General Assembly arguments, or sort of how do you feel good about dividing it up? I love teaching with another person because you really can, first of all, that you can watch each other and notice if I'm talking and Nick is my partner and he's watching the students. It's hard to watch everyone while you're talking. You could watch the people you're sort of making eye contact with, but if there's someone over there who's like, what? Nick can notice that this person over there feels really confused and can say, hey, what do you think she just said? Or let's stop here and recap what was just going on. And it's just something that's much harder to do when you're by yourself, and it's nice to do when you're in a team.
One other probably quick, easy question is, it's been a while since I've had interaction with high school, and the age gap is not so big here. Should we be going by first name, or are they expected to call people Mr. and Mrs. so-and-so?
I think it's totally up to you.
Okay.
Lydia?
Last year, I don't think they said we did.
Ever?
Just
But did you
in
ever
general.
introduce
I mean,
yourself
I
as
introduced
a-
myself, but I don't think they're gonna necessarily be
Okay.
specifically addressing you as Mr. So-and-so.
I think I am just a person who goes by first names in my life, so I always introduce myself as Melissa, and usually the teacher will always say, everybody thank Miss Hart, and usually the students will never have said my name at all, so there'll be sort of a mix of it, but if you're comfortable with first names, I think, I just always find it strange to get up in front of a class and say, hi, I'm Miss Hart. It feels formal in a way that isn't who I am, so I don't do it, but I know that there are other people for whom using first names, talking to a group of younger people feels like not right, so.
Should we expect to field questions about Colorado's new mail-in voting process?
There's a new process?
Huh?
I hope not.
Okay, great, perfect.
What is Colorado's new mail-in voting
There's a
process?
new, I'm new to the state, I haven't been here. Don't they mail you your ballot?
Yeah,
Yes.
but
Has this been around for a while?
a few years.
Oh, cool.
But only
We
like
should know.
Like two
one federal election.
Right,
Yeah.
that's
I
right.
think it
Yeah.
was 14 to start.
Yeah.
But, so, what I was thinking is like, arguably, there's no longer any of the hypothetical ID things if you just receive an absentee ballot or a mail-in ballot and just mail it back. We don't care about any of this?
So that's actually an excellent question. Nick has pointed out that this hypothetical is totally flawed, but I need you to ignore that. And
Got
if
it.
someone does in fact ask, we need to just pretend we live in an alternative universe where it's not flawed. Or it's not Colorado, it's a different state.
If a student points it out, that's a future gunner, and
Yeah.
you shame them right away.
Yeah.
Right
You
there.
belong in law school.
Yes, thank you so much for asking that question, because you are
That's
right,
what I was
that
thinking.
now that we don't have to go show IDs, it
Right,
doesn't
I
make
think that's
sense. But
irrelevant.
in fact, before I make any more copies, I might just change it to another state,
Perfect.
because we still have time to do that.
You can do it.
Michigan.
Arizona?
That's what I thought.
Okay.
But I think I used to.
Make a big statement.
Make a big state. We could do that, that's
West-
what we do
West
in Newport
Dakota.
competitions in high school.
Yeah.
I mean, in law school, yeah. So,
East Virginia.
all right, are there other questions? So, thank you guys very much for coming today, and we'll be following up with assignments. Okay, thank you, Travis.
You're welcome.